So we're back to the judges, DSS, and the fight against corruption. Listen to that. I mean, there's a new twist to all of this, which is where we start off today. And Markwe, go ahead, please.
Thank you, Chamberlain. We have with us Mr. Isaac Anumudu, who is a lawyer and a policy analyst. You're welcome to Sunrise Daily.
Thank you very much, Markwe. It's my pleasure.
A lot has been going on in the judiciary, and a lot of questions are being raised. It would seem that the NJC is also trying to provide answers, or the judiciary is trying to live up by providing answers. We saw the launch of that national judicial policy. There have been some contending parts of that particular policy. Chief amongst them is the fact that when a petition is raised against a judicial officer and taken up to the level of the NJC, that it should not be leaked to the press by either the petitioner or any other member, known to the petitioner, because if it is leaked at some point, the NJC says it will discontinue investigation. And some people have said that that doesn't quite sit right. What do you think?
There are two sides to it. The persons who feel it doesn't quite sit right have a point, because we're in a democracy and things should be seen to be done transparently and openly. And don't forget that the Constitution guarantees freedom of information. There's now a Freedom of Information Act. Freedom of expression is guaranteed by the Constitution and all of that. So anything that, any policy, any direction or directive or law that appears to gag the media, gag the press, Nigerians are very sensitive to that, considering the very important role the media and information played even in the achievement of the hard-won democracy we now enjoy. However, that rule or position by the NJC is also not without reason. The idea and the whole idea is to protect the institution of the judiciary. And that's why you see the mood and the actions the NJC has been taking has been peculiar considering the circumstance. We're not dealing here only with individual judges. We're also dealing with the whole institution of judiciary, which is a co-equal and critical part of the three arms of government that guarantees separation of powers and the carrying of government. And if you allow situations where people can run down that institution at will, then you also have a problem that all of us will suffer eventually. Some of the petitions we know are not always meritorious. We're not saying that there are no corrupt judges. We're not saying there are no actual incidents of corruption in the judiciary. But we are aware that majority of the petitions are not always meritorious. Some are born out of frustrations. When people lose cases, naturally, they are likely going to assume that the judge collected bribe, even when none of such happened. And they will write petitions and be flying it. So if the petition, as unmeritorious as it is first leaked to the press, and the judge is already tried in the public domain, in the media, where the facts are not there to be verified, the judge is not being heard at all. Don't forget, they're not to be heard. That's why most times when issues like this occur, it is lawyers that speak for them. And then before the NJC will come to a conclusion, the public has already come to a decision on the matter. Then the institution of the judiciary will be brought under severe threat. That appears to be the motive for that direction. So there has to be a balance in not allowing any such thing to come out in such a way as if it does appear to gag the media or deprive citizens of their fundamental rights.
So how would you say that the NJC approaches or achieves this balance between the two sides that you've just talked about?
Yeah, the way the NJC will achieve this balance is to be vigilant, actually. And I'm happy with the mood of the NJC at the moment. I'm also very happy with the CJN. In fact, I commend him. He's carried on with so much gravity as this situation requires. So what I suggest is that there will be that critical balance. Yes, that rule is relevant, it's important, it's critical for the danger I've highlighted. At the same time, it mustn't be such that the NJC will be operating in secret, as if it's a secret society. No. There should be deliberate attempts to carry the people along in whatever it does, particularly now that every Nigerian is interested in what is happening, not just in the judiciary, in the legislature, in the executive, particularly on this issue of corruption, because of the huge damage corruption has done to the psyche of the country and the economy of the nation. So Nigerians want corruption wiped out in its entirety. And so whatever steps you are taking in that direction should be open, should be transparent, should be such a way that Nigerians will know what's going on. So where there's a petition, a complaint against a judicial officer, while it's important not to leak that to the media and allow innocent or people who are presumed innocent to be already tried and condemned in the media before the facts are really even ventilated and determined. While it is important to do that, the NJC on its own now should be in the forefront of briefing even the media, briefing the public as to what it is doing, so that when there's a petition, people get to know exactly the process and how it actually ends, so that there will be no, circumscriptions and people, supposing and rumors and things like that. No, that way the NJC will maintain its respect and integrity.
It's definitely, it would seem that it's a double-edged sword, because some people are also saying that, if that is the rule, what says or what's to say that the person who's been petitioned against cannot also leak this particular information just to ensure that investigation is discontinued? Because the rule also says that if in the course of investigation that petition is even leaked, investigation will be discontinued, against the petitioner. And, there are serious questions on the particular one as well.
That was why I started by saying that the NJC will need to up its game and be more vigilant in the implementation of such very desirable but yet delicate policy. It's desirable, I've told you how, and it's also dangerous, I've told you how, because anything that seems to limit or circumscribe or trample with the rights of Nigerian citizens will be highly seen as offensive, considering the dictatorial military background from where we're coming. That's why you even see many Nigerians came out to condemn or protest against the DSS raid. It wasn't as if Nigerians are not in support of fight against corruption. It's not as if we don't think that some judges are corrupt. That is a known fact. In every place, you have bad eggs, both in the judiciary, in the legislature, in the executive. Nigerians would have been very happy to see these judges arrested in a proper manner that does not offend Section 34 of the Constitution, which deals with their human dignity, and does not offend Section 36 of the Constitution, which deals with their presumption of innocence. If they had gone there in the morning at 7 a.m., you can surround the place, tell them you want to arrest them, get them arrested when they've had no time to leave their place, and when nobody has had a opportunity of leaving. Whatever evidence you want to find, you could have found it. Than going at midnight at 1 a.m., breaking the doors with chisel and hammer. These are men with wives, with little children. What kind of trauma everybody, even their wives and children, did they also commit the corruption? What kind of trauma will neighbors and everybody who has been put into? And this makes us not behave as if we are like other societies. So if that has been done properly and they were arrested, don't forget, the judges are not above arrest. They are not above investigation. They are not above search. So if you have your information right, you can go to them, pick them up, investigate them, and Nigerians will only be waiting to see the outcome, to know whether these judges are really innocent or guilty. But when you've carried down in such a Gestapo manner that creates the impression that you're after something, you're not just after corruption, you're after intimidating, suppressing, making these judges afraid, then we're in trouble, because the moment the judge before whom you are appearing is afraid of granting you bail because the DSS may come after him, is afraid of granting you bail because EFCC may come after him, then we don't have any judiciary again in Nigeria. We don't have justice again in Nigeria. And that's why also people like us don't support the call for these judges to step down while the trial is going on. Some of us feel very strongly about that, because also again, from the experiences we are coming from in this country. This was a country where we had the case of Justice Ikomi, who was a judge in the old Bender State. He was chairman of the Armed Robbery Tribunal, and he was, dealing with the armed robbers and refusing to accept bribe. So they found a way to deal with him. And how do we do it? We can't eliminate him. We can't bribe him. So they decided to implicate him. And one of the police officers, who was actually among the robbers, scaled his fence, got into his compound, and killed his police orderly. And the orderly was shouting, "Oga has killed me." Oh. And that was how the judge, his aide, cook, and the other person, 3 of them were charged to court for murder. The man would have been jailed. In fact, he was convicted by the High Court of Appeal. It was in the Supreme Court that Rotimi Williams of blessed memory challenged the Supreme Court and said, "Come, is it only the judge that could be this Oga?" Then they now said, yes, that was a doubt, which was resolved in favor of the judge. After that, the robbery gang was busted, and Osumbo, a senior police officer, who was a member of the armed robbery gang, who was supplying them guns and bullets, was now arrested with Aneni, and they now confessed that they were actually the ones that scaled the judge's fence and killed the judge's orderly in order to implicate the judge. That was when the judge was now discharged, has already been discharged. But don't forget, he has lost his job. He's no longer a judicial officer. And this judicial officer, the dangerous thing is that they can't come back to practice like us. once you live as a judge, you can't practice again. So anything that will tamper with that kind of vested right, we should be very careful. We should be sure that it is done in such a way that only the guilty will suffer. Some of the senior lawyers who are talking are aware that we were taught that it is better for 9 guilty persons to go scot-free than for 1 innocent person to suffer. So we must imagine if we're in the shoes of these people who are presumed innocent under the law, why must they first suffer before their innocence or guilt will be determined? Otherwise, we would have asked the Senate President to go, would have asked the Deputy Senate President to go, and all those standing trial would have asked them to go.
There are many, many perspectives to this, because some people have looked through the new rule book, and then they're raising certain areas they feel a bit controversial. One of them is also that, judges will have to declare their assets before and after giving judgment. We'll come back and explore that after this break. Do join us again.